Any mention?
My lord, I want to mention
Yes.
serial number 8, hearing item, my lord.
Yes.
My lord, in the Finance Bill 2026,
Yes.
an amendment has been proposed
Yes.
to empower the jurisdictional assessing officer to issue notice under section 148. My lord, earlier it was the faceless assessing officer who
Yes.
used to issue the notice. So, and the amendment is proposed with retrospective effect from 1/4/2021. My lord, if the amendment goes through, then this writ petition will become infructuous, my lord.
Yes.
My submission is that the hearing of this case may kindly be kept in abeyance till the bill is passed by the parliament and it receives assent of the president.
We'll do one thing, Mr. Goenka. We'll just adjourn it simpliciter for 6 weeks.
My lord.
Yes. Yes. On
My
the,
lord. And until then, my lord, the interim order.
yes, on the prayer of Mr. Ramesh Goenka, the counsel for the petitioner, matter stands adjourned to after 6 weeks of interim orders, if any, shall continue until further orders. Yes. Obliged, Lord.
My lord, I beg to mention item number 5. This matter can be listed after 2 weeks, my lord.
Where is the petitioner? Yes, Mr.
No objection.
After?
After 2 weeks, my lord.
2 weeks, yes.
Obliged.
Yes.
Item number 1.
May I please, Your Lordship? Your Lordship, as per the last order, we have taken steps, Your Lordship.
Let the file come to my brother.
Your Lordship, the service report is still waited, Your Lordship.
Who are the respondents? School matter?
Yes, Your Lordship, the school matter.
Where respondents are?
Sorry, Your Lordship.
7, 8 and 9.
Yes, Your Lordship.
Yes. When he took steps?
3rd February, Your Lordship.
Yes, Mr. Yes, yes. Just officer indicates that service reports are complete on respondent 7, 8 and 9. Just after 2 weeks for service report. Stop. Appellant is permitted to obtain status in meanwhile and file service affidavit if necessary. Yes.
Item number 2.
Yes, Mr. Smith.
In this matter, we have received affidavit yesterday, Your Lordship.
You file affidavit?
Yes, Your Lordship.
So we will file rejoinder. Day before yesterday, Your Lordship.
What do you want to do then?
We will file rejoinder, Your Lordship.
Ready is the matter today?
Rejoinder, Your Lordship.
Rejoinder. Mr. S. Naitang submits that praise are allowed to file. Rejoinder affidavit filed by the respondents. Appraisal after
2 weeks, Your Lordship.
2 weeks.
We are obliged.
Item number 3.
2 and 3 is connected, Your Lordship.
Same order.
Item number 4.
May it please your lordships. Lordships, as per the last order, lordships have directed us to take steps on the standing counsel for the respondent. Unfortunately, I think standing counsel is not amenable to accepting service, as I understand it.
They said that you go through the department.
Who is the standing counsel?
Mr. S.C. Kayal,
You
lordship.
serve in the department.
I will do that. My lord, state president.
Because the order was specific to the standing counsel, lordship.
Because this is your. How can you sustain this petition also? Take steps again that it is submitted by MCSD that standing counsel that they have attempted to effect service of notice of standing counsel, who however advise them to send the same through the concerned department and stuff. Therefore, please allow further 2 weeks time.
Please,
To
lordship.
effect service, yes. Please allow this up to 2 weeks.
Briefly, lordship.
Item
But
number
the larger question, you be alive to that.
The larger question, lordship, is about appeal. The appeal, lordship, the limitation had expired.
Yeah.
And anyway,
6.
Lordship may bring some accommodation in Lordship in this matter. 6 and 7 in Lordship.
Why?
Because the Paul is out of station in Lordship.
7, I'm for responding 2 and 3.
This is number 7. It's number 6.
6 and
Who
7.
other side? Who's there? Mr. Kayal. Who's Mr. G?
Lordship, in item number 7, I'm for.
No, wait. Number 6. Who's there for other side? Number 6.
Yes, Pandey Lordship. A Pandey.
Mr. Pandey. He's not here. I think they're really ignoring, they're neglecting this income tax thing in Shillong. Who's GC3?
This is Junior Lordship.
Who's junior?
Yes, Pandey is Junior.
Prayers meet for adjournment on behalf of the petitioners. None appears for the respondent. When?
2 weeks.
This is for 2 weeks, yes.
Yeah.
Interim order to continue.
Lordship.
Is an interim order here?
Yes, Lordship.
Yes, MS Rai. What do you want? 7.
7 Lordship.
Item number 7, Lordship.
They're connected matters in Lordship.
These are connected matters,
Oh,
Lordship.
there's no interim order in this number 6.
There is Lordship.
There's not renewed.
This is the last.
Number 7. What is this? Yes. Ready with the matter?
Lordship.
You agree for adjournment? Yes.
Yes,
Do
Lordship.
you have any objection?
No
Mr. Khan,
objection.
sorry. Yes? No objection. Right. On the prayer of so this is after 2 weeks. Adam?
Interim may be continued, Lordship.
Yes. There's no interim here. Where's the interim? Yes.
This is on 30th 10/25, Lordship.
Yes, interim order of any shall continue. Next day.
Highly obliged, Lordship.
Any mention? May I please, Your Lordship, I beg to mention item number 20 in the daily list. I am appearing on behalf of Madam Sharing Yangi as a senior conducting counsel in response to number 1 and 2 on account of some personal difficulties, Your Honor. Your Lordship.
Yes, Mr. D.
I have no objection, my lord.
When? 1 week?
Only for 1 week, Your
Yes.
Lordship.
My lord, item number 21. I have taken the concern of Mr. Sen, that Nehu matter, my lord. Can this be taken up next week, my lord?
Try your luck, okay, after 1 week.
Hello.
Hello.
Yes.
I beg to mention item number 27, Your Lordship.
Number?
27. The conducting counsel S. An is indisposed.
Who's conducting counsel?
S. An, Miss S. An.
I'm for the petitioner, Lordship.
Your objection?
I have no objection, Lordship.
2 weeks now. Yes.
Much obliged.
From supplementary list, item number 1.
Yes.
Please, Your Lordship. Lordship, I'm praying if Your Lordship will kindly take up this matter at the end of the board, Lordship.
End of the board?
Lordship.
We'll issue notice. We'll record Dr. Moska's name.
Lordship.
Yes. So, let counsel review petitioner. So also issue notice steps within 3 days. Just after 2 weeks. Yes.
Daily list, item number 1.
Yes, Mr. Guru.
May it please Your Lordship. Your Lordship, I'm praying for some accommodation.
What's happened?
NG Sheila has she has some medical issue, Your Lordship. She's on leave.
What's our admission hearing today?
My lord, it's been lingering since last 1 year, my lord. I understand, my lord, the difficulty. My lord,
No, Your
my
Lordship.
miscase is pending, my lord. That is why it is in the admission.
This is a fixed matter on Thursday.
Deeply.
No, on next Monday.
Your Lordship, let it come up next Thursday, Your Lordship, because I'm not sure when she'll be able to come back.
19th.
She had surgery, Your Lordship.
Oh. After 1 week.
Deeply.
Obliged, Your Lordship.
Item number 2.
May it please, Your Lordship. Your Lordship, we have already filed a rejoinder affidavit, Your Lordship.
Yes. What's the matter about?
This is regarding the clapping the matter together, Your Lordship. Actually, there is a separate case. One is between Ningmanja and Ningmanja for
Where's Mr.
dispute of Nokmasip.
Lordship,
Another is
He's having some
dispute
personal
of
difficulty,
Dakang,
Your Lordship. Let come after 2 weeks, Your Lordship.
Why 2 weeks?
This matter, my lord, it's not maintainable. On the ground, my lord, the order was passed by this honorable court, my lord. Then the matter has been decided, my lord.
No, he's not. Mr. Moomin is not here. How he's handicapped.
Let it come up next week then.
Lordship, after 2 weeks, Lordship.
Why 2 weeks?
Lordship. If not, then after a week, then Lordship.
1 week, yes. As counsel for the petition, arguing counsel petition is absent just after 1 week, yes.
Item number 3.
Please, Lordship, I humbly praying to Father seeking time to file my rejoinder.
How many times you've taken?
Lordship, actually this is third time because this petitioner is very old. She is
But the petitioner allowed last court to file a joinder.
Lordship.
Just for hearing the meanwhile. After 3 weeks, yes.
Most obliged, Lordship.
Item number 4.
I'm praying for some more time to file affidavit.
How many times have you taken?
This is the third time.
You're in contempt. Which order violated?
There's a stay order. So there's a stay order.
The order? You violated stay order?
Yes, sir. No, Your Lordship. Actually, the main matter is coming up tomorrow.
List together tomorrow with the main matter, yes. As submitted that the WPC 190. It is tomorrow. List the contempt together tomorrow. Yes.
Obliged.
Item number 5.
They'll file an application for implementing the new.
The last, I have filed, Your Lordship, one application to implement the new secretary, Your Lordship.
Where's the application?
yes, yes.
Miss Case on May.
Yesterday we have filed it. It is on 16 February. I've enclosed the appointment order annexure 2 also. That there
It's
is
not come yet. Miss Case stated to have been filed by the petitioner, not yet on record. This
But
after
it will
1
not
week,
come
yes.
also, my lord.
Yes.
Probably it will not come because they have not filed a miscase. They filed an application.
What application you file?
This one is given to me in miscase.
Yeah, this is after 1 week, yes.
Lordship.
Item number 6.
Yes.
T67, he is vacated and hand over the.
Let's see the report. What happened? Handed over to whom?
To this department.
You have handed over the shop.
Report.
So 67, you've recovered possession.
Yes.
What about the other shop number?
Others, shop number, it is not in the writ petition 84.
Yes. Yes.
Other, it is also because the termination order, my lord.
No. What do you have to say with regard to shop number 84?
84, that's also under challenge because in the
No, not a challenge here in the writ petition, correct?
Correct.
Then?
That is
So
still.
we close writ petition. Now, if you have any issues, you file a fresh one. It's not even the subject matter adjudication here, right?
Yes, yes.
Yes, the Advocate Commissioner, Shri W. Dismissal, has submitted a compliance report wherein it is indicated that the petitioner has since vacated and removed all articles from the concerned short number 67, and Mr. Devnath also concurred submissions and submitted that possession has been handed over to the respondent staff. Photographs also have been annexed to show the factum of handing over. So, in this view of the matter, nothing survives the consideration of the present petition, and the same is closed up. The court notes its appreciation for the services rendered by the Advocate Commissioner, C. W. Dismissal. Copy the compliance report along with the attached pen drive is taken on board, made part of the record. Yes.
Item number 7.
This application, just a minute. My application, my lord, has been filed for modification of your lordship's order. I've just prepared a list of dates, my lord, just for your lordship's understanding. Convenience. This is the list of dates, my lord. Your lordship's judgment was on 7th of August 2025. A direction was given by your lordship's judgment to conduct the election, my lord. Now, no time frame was given. Therefore, my lord, in October at serial number 2, I filed an application for modification, my lord, for fixing of a time frame. Thereafter, the state respondent has sought for time and again, my lord. So that has been going on from October till date, my lord. Now, on 27th of January, they appeared before your lordships and sought for further time. Now on the next page, your lordship will see the verification status at page 3, my lord. Now page 4 is what we are concerned with at serial number 66, my lord.
Yes.
Now on the top, your lordships will see KYC, my lord, and percentage of KYC, 5th column, my lord. Now below, your lordships will see 70% is complete at serial number 66.
70.83.
Yes, my lord. So, my lord, this application may be disposed of, my lord, with a direction that within such and such period, my lord, the entire exercise may be completed and the elections may be held, my lord.
Yes.
In the meantime, your lordship, we have also filed an application for extension of the caretaker VC, your lordship.
Yes.
I have
And
no
today
objection.
That has been listed.
I have no objections to that, my
We
lord.
have prayed for 3 months' time, your lordship, because the verification of the job card holders is still going on, your
You
lordship.
got
And we are
only
doing it
70%
diligently.
through. So what
70%
remains
has been
then?
completed, your lordship. But
You
in the
finish it in 6
meantime,
weeks' time.
without a caretaker VC,
So let the
lordship-
caretaker continue
Yes,
for 6
my lord.
weeks and then have elections.
Yes,
positively.
Yes, your
yes,
lordship.
my lord.
We are,
Yes. Where's the minute petition?
this
We can
is
dispose of
registered.
minute petition also.
My lord, it's an application, my lord, filed by me, Miss case number
Now, in the
274,
minute application, what is your prayer?
for modification, my lord, for fixing of
Fixing the
time frame.
frame, your lordship.
I can make.
Main writ is already disposed, my lord.
Already disposed of?
Yes.
Yes, take down. This is MC number 274 or 2025 in WPC number 268 of 2025 disposed of. And where's your miss case?
It's registered as Miss Case 11, your lordship, and that has also been listed to
11? Okay. Yes.
made for 3 months' time, your lordship.
Miss case also. And miss case number 11 or 2026 in so and so. These two misses applications I would regard to the
Extension of
the status of verification of job card holders of Molakandi VEC, and also praying for directions for conduct elections. No, praying for directions for with regard to the election stop. In WPC number 274 2025, the petitioner has prayed for the fixation of a time frame for conduct of the elections, as the said village has been without a VC for
Since August 2025.
25, your lordship. And a caretaker VC has
since
been
August
functioning.
2025 stop. The reasons put up by the respondents are that the verification process, as the verification process was not complete, more time was required. And in this connection, the connected miss case number 11 has been filed. Next part. Today, Mr. Finon counsel for the applicant, petition applicant, has submitted a report containing the status of verification, and a perusal of the same indicates that 70.83% has been achieved. So, he has further prayed that as the matter is, no, the other would prayed that a time frame be given in order for elections, and a definite date, a definite time frame be given for elections to be conducted. MSD Yangi and AAG, policy respondents, submitted that in view of the fact that more time is required, at least 3 months time be allowed before announcement of before the conduct of elections. This court considered both the business applications for fixation of time frame as well as the extension of time. As it is not disputed that 70.83% of the verification process had been completed, it is directed that the state respondents shall complete the verification and positively hold conduct elections within a period of 6 weeks from today. So, both the cases are going to stand as
But Your Lordship, the caretaker VC may kindly be
caretaker
appointed.
VC which is functioning shall, until the new committee takes charge, the caretaker committee in place, until the new committee shall continue to function.
Not one mistake, my lord. One mistake, not in between. Your lordships has said WPC 274. It's miscase 274.
Oh, sorry, this case, okay.
Deep.
And item number 12 is also connected, Your Lordship.
So 12 we dispose of also.
Lordship, we are praying for election in 4 parts of the country, please.
That is different because we can't split the VC, the other are there. We'll take it up independently. Where's Mr. Hassan?
It's out of station.
The other matter is after 2 weeks.
Obliged.
Item number 8.
Go for a petitioner. Was it for today?
No, Your Lordship. Your Lordship, we're praying for some time to file our affidavit, Your Lordship. Items
None
8,
appears.
9,
You
10.
file affidavit.
We have filed affidavit, Your Lordship.
None
On
appears
item 8,
for the petitioner.
9 and 10, we seek time to file affidavit, Your Lordship.
For?
For item 9 and 10, I'm seeking for some more time for
This is item number
8.
The
Your
submit
Lordship,
item
all
number
connected
8
matters.
for
Connected matters.
appearing for whom?
Appearing for UGC, Your Lordship, respondent number 2. Appearing for respondent 3 and 4.
In 8,
Yes.
you file affidavit.
Yes.
Yes, take down none appears for petitioner. MS as long as the place funds allowed 2 weeks further time to file affidavit on behalf of the respondent number 2. So after respondent number 3 and 4 is already on board. Yes, what do you have to see on 9? 9.
9 and 10, Your Lordship, they are connected matters. I'm seeking for some more time to file affidavit. Similar prayer, Your Lordship.
Item number 9. What's your name?
As Dhar, Your Lordship.
Esdar, yes. It's Esdar for respondent 3 and 4.
Yes, Your Lordship.
And MS as long as the for number 2. And Esdar for 3 and 4. Pray for allowed further 2 weeks time to file affidavit.
Much obliged, Your Lordship.
10 also.
Yes, Your Lordship.
Same order 10.
Item number 11.
Where's the rejoinder file?
Lordship, since Lordship has given 2 weeks to file the affidavit, so Lordship, I have not received their affidavit till date. So if Lordship permit, give me 1 week, I'll file my rejoinder.
You have not filed.
Lordship, I'll file my affidavit during the course of the day, Lordship.
The rejoinder the other one you have already filed. 1 and 7.
Yes, Lordship, I'll be filing my rejoinder after receiving their affidavit, Lordship.
MS.
May it please Your Lordship.
Yes.
Lordship, the Merrick Act has been scrapped, and the new act, that is the Big Sit Bharat G Ram G Act 2025 has come into force, Your Lordship. I don't know whether this.
It will come in the 1st of April, Lordship. It will be enforced in the 1st of April 2026. So we still have time.
Will be coming into passing of this act, Your Lordship. Whether.
So what impact will it have? It has retrospective effect.
Lordship, let me examine that.
Will it have retrospective effect or no?
Lordship, I think there must be certain provision, Your Lordship.
Have you seen the new amendment?
Lordship, I have not seen it.
Then, how do you see it be unfractious? Yes,
it cannot be.
Allow submits that on receipt of the affidavit from 8 and 10, which is as submitted by MS Rahman being filed the course of the day, the agenda will be accordingly filed within 1 week.
1 week.
Yes. Just after 2 weeks, yeah.
Let me 3 weeks, Your Lordship.
2
1
weeks,
week.
why you wanted Dixit Bharat to come first?
Lordship, 1 week.
1 week.
Oblige.
Oblige.
Item number 13.
My lord, in this matter, I am appearing for response number 7. I have received a paravis comment, my lord. I am praying for 2 weeks' time, my lord, for filing my affidavit.
And for the petitioner, Your Lordship.
Who is appearing?
Bishop, I have a similar prayer for respondent 9.
9.
9 is the village. Nali.
Yep.
Set up in my village.
Whose number? Whose number? You're for 7.
7, my lord. Shillong Municipal.
Number 4? Who is for state? You all file affidavits? Councils, huh? Yes, all of you will file affidavit. Mr. Long.
Yes, yes,
filing. Yes, all councils for respective parties, apart from respondent number 7, pray for and allow further 2 weeks time file affidavit. Just thereafter. Or for number 8, sorry.
14.
You're supposed to file the status report.
Mate, this is Your Lordship.
Yes, where's status report?
Lordship, Lordship, the case has been charge-sheeted and charge sheet has been filed.
Where's the status report?
Lordship. I have a charge sheet.
So fast.
This is the charge sheet, Your Lordship.
I have a copy of the status report.
Charge sheet.
No, only 2%.
Lordship, yes. Then,
who are the respondents here?
My lord, the respondent is Mr. Cleophas BCM.
He's not been charge sheeted.
No, Your Lordship.
Nothing against him.
My lord,
Lordship.
the trust.
Lordship, kindly see the prosecution story, Your Lordship, at page 3 of that charge sheet.
One second.
The respondent number 5 is not charged.
These people charged, they're not part of the, they're not respondents in the.
Lordship,
my lord, what has happened is my lord will kindly appreciate here.
These are the goons, respondent number 5 being charged sheeted.
No, my lord.
Then?
My lord, what has happened here is, my lord will please appreciate that the FIR was filed on 21st. The FIR was kept in cold storage, not acted upon. The petitioner approaches the High Court in the month of December. Then thereafter, the FIR is finally registered. And now, at this lightning speed, the FIR is charge sheeted, and we are told that the principal respondent against whom the FIR is filed is not charge sheeted. And my lord, it is my submission, it is on record that the trespassers still continue to be there, my lord.
Lordship, then what happened, Your Lordship?
And my lord,
petitioner,
the civil suits are
on 3rd February, they have filed one application, Your Lordship, for restoration of the possession. Lordship, kindly have the order passed by the trial court. High Court of
My lord, this is a case where there was a civil suit, my lord. And in the civil suit, a status quo was ordered. The status quo was blatantly violated by the use of criminal force, against which we filed the FIR. The FIR was not registered.
Yes, the resource rubber plants.
Yes, my lord. Yes, my lord.
Case.
Yes, my lord. My lord, this is where the resource rubber plant is, my lord. My lord, I am the local director. The petitioner here is the local director.
Your Lordship, that is Miss Case number 4 of 26 under section 151 CPC, Your Lordship, for restoration of possession.
My lord,
the London trial court, Your Lordship, has fixed that matter on 10/3/2026.
My lord, that is a separate matter, my lord. The civil suit is pending. There was an injunction which was passed as early as in the year 2000 in 2024. Now that injunction was blatantly violated by the respondent number 5, my lord. The respondent number 5 has not even entered appearance in this case, my lord.
Why is not entering appearance?
My lord, clearly this respondent number 5 is, yes, my lord, he has been sheltered.
I have no idea.
It is very clear, my lord. Otherwise, at this lightning speed, the charge sheet would not have come so fast. And that too only when the court has taken cognizance of my writ petition, summoned the IO here in person before this court. Thereafter, he registers the FIR and then he files a charge sheet against a person. I have not seen the charge sheet, my lord. I have not seen the charge sheet, but it is my learned friend's submission that the charge sheet is not filed against the main perpetrator of the offence, my lord, of the trespass, that is.
You file a writ
one
petition.
thing, Mr. Gautam, we have to distinguish whether the entire dispute,
my lord,
is in the realm of a civil dispute,
Your Lordship.
or whether criminal elements may be breaking of CCTVs and that kind of thing might happen in connection, but whether basically it is the whole, it's a civil dispute only.
My lord, there is no dispute that there is a civil dispute.
Then there's a suit
the civil
pending
dispute is pending since 2024, my lord.
Fine. Now
Then
there is a civil, and now what about your application for restoration of possession?
My lord, that is the court has taken cognizance of it.
Then
my
how
lord.
can you be trespasser if you're out of the property?
My lord.
Now you're seeing the trespassing. At the same time, on one hand, regard the same property.
My lord, he has
application for.
My lord, he has trespassed into the property using criminal force.
Dispossessed you.
My lord, he has partially dispossessed me from the property, my lord.
See, we can't go into that now.
Lordship.
My lord, if I may
You
have
file
a
an
copy of the
application,
statute,
go for local inspection. You file before the concerned.
Lordship, if there is a violation of the status quo order or at interim, there is a.
My lord, we have already. My lord, that we have already done.
Lordship, can he have the letter?
My lord, just because there is a civil flare, my lord, there is a civil element or there is a civil dispute, my lord.
Start from civil dispute only.
My lord, it emanates from a civil dispute, my lord.
Right, then.
It emanates from a civil dispute, but the civil dispute is a very old civil dispute. Now, in the pendency of the civil dispute, my lord, he uses criminal force, he brings goons and all that. He trespasses into the property, my lord. He trespasses into the property. He holds the entire rubber resource plant in ransom, my lord. He has vandalized the entire thing. We filed the FIR, my lord. My lord, will please appreciate. If at all the police was, my lord, if at all he did not have the blessings of the high and mighty of, if I may use that term, my lord, then, my lord, how is it that the FIR was not taken cognizance of when it was filed? Only after I came to the High Court, my lord, thereafter the FIR was taken cognizance of. And I have been repeatedly submitting before my lords that the trespass still continues till date, my lord. And my FIR is against a trespass, my lord. Trespass using criminal force.
Petition has been filed.
My lord, will kindly
FIR.
Will you issue a bill warrant of arrest to the five first appearance in court?
Lordship, I have.
Let us hear it from the horse's mouth.
No, my lord, nothing has been done. My lord, is my learned trying?
5 days not appearing. He's been served.
Yes, my lord, he has been served.
Then
I have no.
He has been served, my lord.
Make any submission on his behalf, your lordship.
Of course, you cannot.
I
But I'm
cannot
saying
make.
we should.
Only thing, your lordship, the writ petition has been filed only to register the FIR. No action has been taken by the police. FIR has not been registered. That we have done, your lordship. Then we have filed the charge sheet, your lordship.
The thing is that Mr. Gautam.
Yes, my lord.
And the investigation of the case also reveal, your lordship.
My lord, a civil dispute. My lord, I am not. My lord, that is.
There is a civil litigation.
My lord, there is a civil litigation. There is no doubt about that, my lord. I have made clear averments in my writ petition, my lord. I have also enclosed the orders that have been passed by the civil court, my lord. The order of injunction. The order of injunction which was passed. The order of status quo which was passed by the civil court, my lord.
See, the thing is that as of now,
my lord,
your FIR has been registered.
My lord,
you've taken steps upon
my lord.
You've charged it whatever ABC they might be.
My lord, my lord. Now, of course, my lord. The court will
close this matter now.
My lord, of course, it can be closed, my lord. But I am.
Then you can take recourse to other remedy.
My lord, with liberty.
7, if it is, that is.
My lord, with.
Yes, sir. Mr. NT.
My lord, a copy of the status report, a copy may be given to him.
Lordship, we can share the case at that is the case diary, your lordship. Only.
It's not a case diary.
Lordship, yes, from the case diary only, your lordship.
See, anyway, we're not making any comments. Take down. A serious report has been filed today. Not serious report. Documents have been produced today by the London AAG, wherein it is seen that certain persons with a connection with the FIRs filed by the writ petitioner have been charge sheeted. This court notes that the allegations have been made against respondent 5, who has chosen not to appear before this court for reasons best known. His name does not appear in the charge sheet. Stop. Though the limited prayer of the petitioner has been met at this stage, this court closed the petition, however, with the caveat that rule of law should prevail and continued investigation or necessary action should be taken against all persons named instead of IFIR. This matter stands disposed of.
What you will permit me to take back that?
Oh yes.
My lord, my friend will kindly give me a copy of the status report filed.
Depends on your persuasive capacity with the AAG.
My lord, it is very difficult to pursue the state in matters like this, where they have
then you can't, yes.
more than active interest, my lord.
But we understand, yes.
15.
Please, Your Lordship.
You have paid substance allowance?
No, Your Lordship.
Why not paying?
Your Lordship, as per the instruction I have received, Your Lordship, there are some serious allegations, Your Lordship.
Even if suspended, he deserves his substance allowance.
Regarding the qualification certificate, Your Lordship.
No, was he teaching in your school?
Yes, Your Lordship.
Was he given regular salary?
Yes, Your Lordship.
Then you suspended him now?
Yes.
Then he pays substance allowance.
Regarding that, Your Lordship, for the qualification, Your Lordship.
Qualification doesn't come in the way at all. If he was teaching, you were paying regular salary, you drawn up proceedings against him, that will take his own cost, but he can't be left to starve.
Your Lordship, but...
when can you pay? By tomorrow?
Your Lordship,
yes.
We need...
Yeah?
We have filed an RTI, Your Lordship, and it is
what
found
RTI?
Tempered everything, Your Lordship, documents and all.
Where's your suspension order?
Suspension, my lord, is that's Annexure 9. Annexure
He's not
10.
against, he's not challenging the suspension. Where's it, Annexure?
Annexure 10, my lord.
Annexure 10.
Page 25.
See, Mr. Chaudhary.
Yes, Your Lordship.
He's not challenging suspension also. You are free to take whatever. See. The writ petitioner, the complaint of the petitioner before this court is that though he has been placed under suspension since 7th April 2025, pending disciplinary proceedings against him in connection with the services. In what school is this?
This is Roni Asim Defense Secondary School.
Deficit in connection to services in Roni Asim Deficit Secondary School, where we're serving as a school teacher.
Assistant teacher.
Yes, assistant as a science teacher. Form number. And so he has not been paid a substance allowance. Mr. Z.A. Chaudhary, Learned Counsel, appearing for respondent number
4.
Respondent number 4. You do not deny he has not been paid substance, huh? Number 4.
For that, Your Honor, I need to take instruction, Your Honor.
Submits that he has been paid or not? He has not been paid.
Since
submits that as serious
July.
allegations against the petitioner with regard to fabricating documents.
Yes, Your Honor.
In connection with employment.
B.Ed document.
Yes, and as such, proceedings have been drawn up and he was placed on suspension. This court next notes that the challenger petition is not to his substantive suspension or proceedings or proceeding, but only with the factum of non-release substance allowance to the writ petitioner. So, in these circumstances, it is not disputed that a writ petitioner was serving in the school respondent number 4. Respondent 4 directed to release the substance allowance forthwith. Yes.
Just one small correction, my lord. This order was issued on 7/4/2025, but has been made effective from March 10, 2025, retrospectively.
How we respective? The middle 7/5 you paid. Substance allowance only with regard to the from the time you put under suspension, so you're not allowed to attend to your duties, and you proceeding that commence.
No, I'm just saying regarding the order. The
The order is dated 7/5, doesn't matter.
All right.
Forthwith, preferably within a period of 6 weeks from today. 4 weeks is. See, this is right. It's not a question of contest.
Yes, sir.
16.
Your Lordship, service has been completed. Has been completed to all the responding, Your Lordship.
Lordship,
So now what are you appealing for?
I am entering a prayer on behalf of 4 and 5, respondent number 4 and 5. Lordship.
Four and 5.
Yes, Lordship.
That is
the
private respondents.
Private
What about
respondents.
number 6? Yes, if he's been served.
Yes, Your Lordship.
Mr. H. Nongklau.
May I please, Your Lordship, have some submissions, Your Lordship.
1 second, yes. What do you want?
Lordship, in terms of Your Lordship's order, we had taken steps. We had issued notice because there was a representation filed by the petitioner. Your Lordship has noted in the previous order.
What's the previous order?
We've been directed to take steps on the complaint filed by the petitioner, Lordship.
Yes.
Your Lordship.
Now we have looked into the matter, Lordship, and notice have been issued to all the concerned parties. Now the revenue officer will take steps and pass necessary orders.
So what was the matter?
Your Lordship, till the Lordship, they haven't passed any order
You will
regarding
pass-
my complaint, Your
Yes,
Lordship.
you see, the order says last time, it appears the matter concerns the challenge to issuance of landholding certificate in favor of respondent number 4. The complaint is filed since pending disposal. In these terms are the matters also. So, Mr. H. Nongklau entered appearance on behalf of respondent
4 and 5.
4 and 5 today. None appears on behalf of respondent number 6. Those submitted that he, office number 6 4 and 5, however, office note indicates that service is not complete. Respondent number 6. Stop. Next paragraph. Mr. M.L. Nongpur, counsel for respondents 1, 2 and 1 to 4, 1, 2 and 3.
1 to 3, Lordship.
1, 2 and 3 has submitted that pursuant to the order dated 17/12/2025, the respondents have taken steps and the revenue officer will shortly be passing appropriate orders in connection with the complaint filed by the writ petitioner against issuance of landholding certificate in favor of the respondent number 4. So, next, in view of these circumstances, nothing remains for consideration. However, it is expected that the order be passed within a period of
2 months, Lordship.
2 months from today. Yes. Matter will stand disposal. No objection to disposal, Mr. Nongklau?
No objection.
17.
Please, Lordship.
For affidavit, I'll frame some more times.
Lordship is supposed to take steps on to perform a defendant, respondent number 11 and 12, Your Lordship. Your Lordship, no, Your Lordship. We have not taken. I'm playing for 1 week time, Your Lordship. We'll take steps and then we'll file affidavit of service of notice also, Your Lordship, within 1 week.
What about 1 to 10?
I'm for 1 to 6.
1 to 6.
1 to 6.
You want to file affidavit?
Yes,
Mr. Dr. M. JCI, with so-and-so, praise funds allowed.
3 weeks time.
3 weeks time to. What about you? You're filing affidavit? No.
We have not received instructions.
Yes. Amazon only praise allowed to the praise allowed 3 weeks. Prayers also made on behalf of response 7 to 10 by learned government advocate that can read for further time to obtain instructions and to file affidavit. Prayers allowed, yes. MS Bisun, please be given submit 32 inadvertent steps were not taken on respondent's number. That is number
11 and 12, Your
11
Lordship.
and 12. She prays for and allowed for that time takes such step. This up to 3 weeks. That's for the orders.
Give you much.
18. Your Lordship, in this matter, we are awaiting instructions from the department.
When was it filed?
This was filed.
This
on
was filed in
15
December.
25.
What's the matter about?
This is regarding constitution of a departmental promotion committee. That is what is the grievance.
Which department?
My lord, who were never given promotion.
Community and road development.
Okay, which this is what Gram Sevak?
Yes,
Gram
ma'am.
Sevaks and Sevikas.
As
They were
further
promoted
2
on
weeks time
March.
allowed to the state respondents to obtain instructions to file affidavit. Yes, thereafter and so on.
3 weeks, Your Lordship.
3 weeks.
Because we
Okay,
need
3 weeks.
instructions then.
19.
Obliged.
Obliged, Your Lordship.
19.
I'll just take the causes.
Well, in terms of Your Lordship's last order, my lord, they were required to place instructions.
You're allowed to meet now.
Allowed, my lord. Allowed.
The disposal of
Lordship, yes.
whatever like wrongful arrest that you can.
My lord, there
It is not a wrongful arrest, Your Lordship.
No, they're alleging wrongful arrest. The court
That is
saying
not
wrongful arrest.
factually incorrect, Your Lordship. That is a misleading statement, Your Lordship.
No, my lord.
He
Here,
was granted the bail by the Honorable Supreme Court, Your Lordship, with a stipulation that he should cooperate with us. He failed to do so. We filed our application for cancellation of the bail. That bail has been cancelled, Your Lordship.
and while, my lord, on my way to surrender myself or even to cooperate with the investigation, my lord, I was arrested midway from the airport, my lord, by the police who has no jurisdiction over that area.
Against that cancellation of bail, Your Lordship, they file a criminal revision, Your Lordship. It's being taken up today.
Then will you take this matter together? You filed the miscase in the criminal proceeding.
Lordship, yes.
With regard to the arrest.
If I may pray, my lord, can we have this matter day after, my lord?
And the bail
I'll just
we
seek
have
instruction
filed
with
bail
regard to
application
any
also.
other
It's being
issues
taken
that
up today, Your Lordship.
the petitioner might be facing, my lord.
3, Your Lordship.
Just day after tomorrow.
We can't extend the prayer. Your prayers for to meet defense
No,
counsel.
my lord, there was no interim order granted also, my lord. I'm only praying for day after, my lord. I'll see if any grievance is left. I'll seek and agitate. I'll try to agitate.
See,
Otherwise,
we have
my
a
lord,
criminal petition pending.
And also a bail application, Your Lordship.
that's on a different, my lord, cause of action.
Why?
That is with regard to cancellation of bail, my
The
lord.
court has enough power. You can only file a application for 42. They have enough power.
But that is with regard to cancellation of bail.
Yes, if things are not as per procedure under BNSS or BNS, whatever now, you have recourse to you're in a criminal
Yes,
court.
certainly, Your Lordship.
Yeah, the only thing is whether your rights have been violated or not with regard to your
In a revision
allowed to-
petition, my lord,
your prayers
whether
that
I'll be
you be
allowed to
allowed to
agitate that.
consult your defense counsel. So that's been allowed.
My lord, I'm only praying, my lord, may have it day after tomorrow. My lord, if there's anything left, my lord, I'll try and agitate, otherwise not. Kindly have it day after tomorrow, my lord. Just a day after.
Those two matters also coming up day after tomorrow, Your Lordship. Bail application as well as the criminal revision also coming up day after tomorrow, Your Lordship. On the
Okay, it is reported by the learned Additional General that the red petition has since been see at the time of the arrest was signed with a lawyer also. He was there.
Lordship, yes.
I'm not sure, my lord, of that aspect.
The annex did, annexure 2, yeah, signed by. See,
Let them give us a copy of this.
Nominated Chatterjee. Who's he?
He was accompanied, it seems, my lord.
Lawyer, your
by-
lordship. Santanu Chatterjee is a lawyer. Lordship, kindly have a paragraph 2 of that reply, your lordship, to the SP. His lawyer, Santanu Chatterjee. I'm praying, lordship, for closure of the matter, your lordship.
Let this report be given to us, my lord. Let us at least have a look at it.
Yeah, give the report.
Lordship.
Report's been filed on behalf of the respondents 5 to 8, indicating that the petitioner always had access to legal counsel. With the initial and AG, please the matter be closed at this stage itself. But however, Ms. S. Thapa raised that he may have a copy of the status report and the matter be posted thereafter. Otherwise, it might inflict costs if it's the allegation is false.
No, there's no question of we alleging anything false, my lord.
We don't know.
He was granted the bail by the Honorable Supreme Court, your lordship. He flouted the condition, your lordship.
It's called a mediation.
From the mediation, item number 29. Mediation, item number 29.
29. Clarinda.
Clarinda Moment. Mr. H. Zarika. Yes.
Lordship, so far as state is concerned, we have no.
Where's the petitioner? You're for a petitioner. You have any objection to mediation? No, you have no objection. That requires normal order.
Item number
Public
30.
parties have no objection if the matter is referred to mediation. Accordingly, referred.
Apply, your lord.
Item number 30.
Rajesh Hajong.
Lordship, the petitioner is not willing to.
Not willing. Not willing.
Because this is a dismissal of the service. Disciplinary proceeding was initiated against the petitioner.
Yes, petitioner submits that the petitioner counter petitioner submits that petitioner is willing for mediation. According to this on when?
Lordship, let it come after 2-3 weeks. Lordship.
For hearing or
yes,
still
Lordship,
in the
for
order
hearing.
stage?
Lordship.
This is in hearing, my lord. Hearing.
31.
You are willing?
Yes, Your Lordship.
Who's
but,
other side?
Mr. Majumdar.
Where is he?
It's from Guwahati.
Not looking post for mediation aside. Not looking post any matters for mediation. For this. Oh no, when are you going to post that? There's MSGC Marbo, who is present on behalf of the petitioner, submits that they have no objection. The matter is referred to mediation. However, none is present on behalf of the respondent. Just after 1 week, yes.
32.
My lord, 32 to 37 are connected matter. So, my lord, on instruction, my lord, state is not willing to go for mediation. There is no scope, my lord.
Ready for hearing?
No, no, see.
Yes, State Council MS article submits that in these matters, the state is not inclined for medication, not mediation, but medication. Just after 1 week.
My lord.
For hearing, yes.
32 to 37, my lord.
38. 38.
This is a matter where CRP have recruitment. We challenge the territorial jurisdiction.
Lordship, we're ready for mediation, Lordship, if they consider our prayer, Lordship.
What's there to mediate?
If they consider our prayer, Lordship.
Though the petitioner is agree with mediation, Dr. M. Boskia, DSGI, submits as a matter concerning territorial jurisdiction, there's no scope for mediation. How is the scope for mediation? Can mediation say, okay, you have territorial jurisdiction? Yes.
39.
Well, it is for regularization. I don't know how far it can be.
My lord, here also, my lord, we are not willing for
Non-inclined.
my lord.
The parties submitted not inclined for mediation. Just after 2 weeks for hearing.
40.
I'm bringing forward that service matters cannot be go for mediation.
40 and
Yes, Your Worship. Yes, Your Worship.
I don't know 40.
Do you want mediation or don't want mediation?
you want or you don't want?
You don't. I don't want mediation.
You don't want mediation.
Yes. Controversial.
It is a service matter.
Yes. Service matters they can go mediation also. Who says they can't? Yes. The party petitioner submits that the petitioner inclined to mediation. It's after 2 weeks for affidavit. Affidavit.
Yes.
Yes. By the respondents. Yes.
41.
May I please, Lordship? Item number 41, my lords, pertain to the non-communication of ACR. So this matter may not be sent to for mediation, my lord.
They will pass all this. This is, have you filed affidavit?
We have not filed.
It can be disposed of, my lord. Affidavit has been filed before the Guwahati High Court.
We'll file affidavit in the meantime, my lord.
They don't file affidavit. Yes, parties submit that this matter is not fit for mediation as it is a covered case. So accordingly, this, however, the prayer of Dr. Mozika, it's a matter of 2 weeks for affidavit. We'll dispose it of once after it's on record.
My lord.
42.
42 to 45, my lord, prayer for disability lump sum compensation. So these matter may be sent for mediation, my lord.
Yes.
Can go.
Yes. 40. How many items number?
42, 43, 44, 45.
Yes. But council ties submit that they are agreeable for mediation. Yes. Accordingly,
my lord,
matters is referred to mediation. Yes.
My lord, much of lordship.
From hearing list, item number 22.
Please, Your Lordship, before they start, Your Lordship, I'd like to point out certain things, Your Lordship. The prayer which they're seeking, I'm for the bank, Lordship. This is respondent number 9.
1 second.
The prayer which they're seeking is to defreeze the account. That has already been done, Your Lordship, by order dated 3rd of June 2025. And the other prayer that they're asking is for speedy trial, speedy inquiry, investigation. So that is the only thing left. Now, if we're doing a hearing for that one, there's one important thing is that now Kerala police has not been made a party in this matter. So it's only Telangana and Andhra Pradesh are made a party, and Tamil Nadu. So they have to be on board, Lordship.
No, there are two things, my lord. Firstly, my lord, the amount which was debited from my account subsequently after filing of this case, my lord, that was done by the Kerala police on the basis of some case pending somewhere else.
It's not correct, Lordship. It's in my affidavit.
Until that period of time, my lord, when this case was instituted, my lord, Kerala police were not in picture. It was only Telangana, my lord, Hyderabad.
The first time it was, I'd like to interrupt, Your Lordship. The first time it was freeze was done by Kerala police. Second time it was freeze by Telangana and Tamil Nadu. The third time it was freeze, they had filed this petition in the month of December 2024. Freezing had happened in the month of October by Kerala police. It's in the affidavit, Your Lordship, page 2.
It was done twice. Earlier, they freeze my account.
Where is the case instituted?
They say that it's now in Kerala.
Everywhere is in Kerala. At the moment it's in Kerala. There's a proceeding before the CGM there in Kerala.
No, be that as it may, my lord, one thing which is very important
the cause of action is there.
that I should bring to your lordship's notice.
They have filed an FIR here before Ranjha Police Station. Ranjha Police Station were able to file only information that this matter is there in Kerala.
My lord, till today, my lord, the respondent bank is in contempt of this Honourable Court's order. My lord, may kindly have 6/12/2025 order.
Which bank? Canara Bank?
SDFC, my lord.
SDFC.
Where's the order?
6/12, my lord, 2025.
Yes, 16/12 or 6/12?
Sorry, 16/12.
Yes.
I'll just take your lordship to the second paragraph. I'll start from second paragraph.
Yes.
Though it is submitted by so and so learned counsel for the petitioner that the same is not to his knowledge, the instant matter will receive further consideration by the court, especially with regard to the status of the other respondent who have not appeared in spite of service of notice. Accordingly, it is directed that the account number so and so shall be unfrozen. My lord, we wrote to them, my lord, bringing to their notice that this is an order passed by the honorable court. Now, in spite of this order being communicated, my lord, even though they have unfrozen my account, my lord, there are certain amount which is kept under lien. Still, for what reason, nobody knows. My lord,
No,
the
but can you
order,
operate your account? What is the amount been kept in the lien?
1,45,000, my lord.
That been kept in the lien.
Yes,
But you can operate your account otherwise.
I can operate, but still, my lord, if I cannot use my money, my lord, this order becomes redundant. My lord, and moreover, this order is not conditional order, my lord.
Yes. Why you done that?
Your Lordship, that is, I don't have the instruction, Lordship. As far as that is concerned, the only thing we have done is, when it come to order dated
Who's the
14...
chief manager in Shillong, HDFC?
Lordship, sorry.
Who's the chief manager? Where's
cluster
the
manager
head
is
office?
there.
In Shillong, I mean, it's Police Bazaar.
Police Bazaar. That's a branch manager. So, Lordship, it's
Now,
very
who's the
important.
competent authority to which branch is your account?
My PB branch, my lord, Police Bazaar branch.
Lordship, the only thing that was done to this account is the compliance to the order of the CGM from Kerala. That's the only thing.
Yeah, that chapter is closed, my lord. As
that
of now,
chapter
the
is
chapter
closed
is
and the
closed.
account is unfreeze. As far as that putting it on lien, that we do not have it now, information. That I
Let
can
him come
confirm.
clear on this, my lord.
Let
I
us
have a
get
very
the
specific instruction
And
for
in
my
the meantime,
client, my
Your
lord.
Lordship, Kerala Police, Cybercrime are required to be on board. In my affidavit, is very clear that the last freezing was done by the
It's a very
instruction.
complex case because see, it involves how many banks. See, the official memorandum which is sent by from Kerala.
Yes, sir.
Udiki. Udiki is in Kerala. Was in Tamil Nadu.
Kerala.
Kerala, yes, Kerala. See, as per the reference cited above, so and so, yeah, an amount 20,000 found in Mangodi branch, Canara Bank, an account of so and so. Then another one found in Vasundhara Ghaziabad branch, State Bank.
Yes, sir.
Another one is found in First India Place branch of HDFC in the name of so and so. Then Shillong Police in the name of Green Johnson. And
In fact, this-
account of so and so. Well, can't understand. Found
Yes, sir.
Ajmer State Bank.
In fact, this person, the complainant,
So the thing is that now
Nobi Joy also has to be made a party.
the money of this complainant, whatever in
Yes,
Kerala, is gone all over the country.
It appears like that.
How much appears like this?
It appears. It appears like
yes,
that.
my lord.
So even Nobi Joy is
So
also.
the, one amount's gone to what?
There's no
So this
clarity as to
person,
what amount has
Nobi Joy,
gone
the
to which.
complainant,
Hyderabad is gone to Ajmer, is
Exactly,
gone
yes.
to God knows where.
So, Your Lordship, this Nobi Joy also has to be made a party. This is a necessary party. Kerala Police and this person
petitioner.
concerned. Yes, Nobi Joy. The address is also given, so it's easy.
Now yes, there's the latest ruling of the Kerala High Court also in this matter. That before anyone comes for defreezing,
The magistrate's order is
yes,
magistrate's order, my lord.
no, the police verification report should be filed together with your application to show that you should show your bona fides. I have not seen the judgment, but that's what it says. Anyway, this is a very complex matter.
If they so desire, my lord, we'll make Kerala Police a party. There is no problem.
Have to implement.
Kerala Police is a necessary party. Then they can only give clarity as to what is this case about. Number one, the multiple accounts, multiple deposits all over the country.
And
You're
also
just
the
one of
complaint.
them.
Right.
It's just one of them.
And also this person concerned, the Nobi Joy, the
That's
complainant.
up to them. What's happened to other accounts, other people who are similarly situated like you?
Well, I'm not really sure of the other people, my lord.
They are respondent number 5 in this case here. Killeen Johnson.
No,
Yes.
fine,
Yes, my
but
lord.
the repetition is fine. But the thing is that in this memorandum given by the CJM,
Yes, sir.
it named how many cases there are, how many people,
Altogether 11 here.
multiple accounts.
Yes.
And this order was communicated after the order was
Whatever
passed.
it is, but the thing is that, yes, Mr. S. Thapa, please we allowed some time to implement necessary further necessary parties such as Kerala Police or the original complainant of, you'll get the number here, Nobi K. George.
Nobi K. Joy, ma'am.
Joy, sorry.
Yes, that's the complainant.
As of Thama? Kerala Police, there is a concern, that is which station is this? Any human rights organized parties such as Kerala Police and also the complainant in the original case. This is after 2 weeks.
Let them also come clear on why they are.
I'll get instruction on the.
As for one also, to obtain instructions on the status of the account of the petitioner, which has been directed to be unfrozen. Yes.
If there's any lien on any amount, my lord.
Let them come.
I'll clear it. Purchase.
23.
Very strange.
23.
May it please your lordships. My lord, writ petitioner herein, my lord, is a sub-inspector, my lord, in the taxation service of the Khasi Hills Autonomous District Council. Now, my lord,
taxation?
He is a sub-inspector of taxation. This belongs to the, there is a taxation service, my lord.
They have governed by.
They have rules, my lord. Well, please, my lord. Now, my lord.
All are ready?
Yes. Yes.
Now, my lord, as per the rules, my lord, the admitted position is this, my lord. Next promotional post is Inspector, my lord, of taxations. Inspector of taxations. And the mode of promotion is, my lord, based on
seniority.
No. Merit cum seniority. That is the admitted position, my lord. Merit cum seniority. Now, my lord, so far I am concerned, your lordship, I have entered the service, your lordships, of the District Council, my lord. Of the District Council, your lordships, in the year, my lord, 2003, as Assistant Sub-Inspector, my lord. Thereafter, my lord, I became, my lord, Sub-Inspector of Taxation in the year 2012. And, my lord, by 2024, my lord, two position of, my lord, Sub-Inspector, Inspector of Taxes, all vacant. And, my lord, in the cadre of Sub-Inspector of Taxation, your lordships, I was the senior most.
How many sub-inspectors are there?
My lord, there are as many as your lord.
The zone of consideration?
10, your lordship.
10?
10.
Yes. Okay.
My lord. So, my lord, I being the senior most, my lord, at least I became eligible for consideration against this post. Now we have filed, accordingly we have filed representation, my lord, before the authority. If I can take, my lord, to page 17, annexure 1. The memorial, I'll just read it. With profound honor, we undersigned through the presentation letter would like to inform you the post of Tax Inspector Taxation Wing are lying vacant since the demise of such and such and retirement of such and such. Therefore, we would like to bring to your kind attention that we have been serving in the Council for Civility as Sub-Inspector of Taxation's Wing. During these years, we have acquired extensive knowledge and experience in the field. Furthermore, we humbly request you, sir, to consider our promotion to the present vacant post of Inspector, which we highly rightfully deserve on the basis of seniority level among the Sub-Inspectors serving the Council of Taxation Wing, hoping anticipation, etc. etc. My lord.
Yeah.
Now, my lord, we are expecting that we will be considered for the same, my lord. But to our shock and surprise, my lord, we came across, my lord, we are never intimated that we are under consideration. We came across, my lord, the next letter, your lordships, Annexure 2, 6 January 25.
Yes.
In the interest of the Council Service, Executive Committee, Khasi Hills Autonomous District Council is pleased to promote the following Sub-Inspector of Taxation for the post of Inspector in the pay structure such and such. You shall announce as admissible such and such. These are the two persons. My lord, this is what I have impugned here. Now, my lord, seniority wise, my lord, though it is merit cum seniority, my lord. Now, my lord, they are well below us. But it can be. I understand, my lord. Merit cum seniority, it can be.
Well below you in terms of?
In the seniority list. In the cadre of.
But they were eligible for promotion.
They came within the zone of consideration, my lord. That I am not disputing your ship. Otherwise. Now, my lord. Now, my lord.
Represented here.
Yes.
Yes, there. Now, my lord, the law is, my lord, when it comes to merit cum seniority, my lord, they will have to have a, my lord, very objective criteria, my lord. On what basis they have been promoted, my lord, superseding the seniors. How they are more eligible than me, my lord. They need to have a, my lord, transparent, objective criteria, my lord. They have nothing. We file this. Now, my lord, interestingly, your lordships, District Council has filed an affidavit. In the affidavit, my lord, the ground they have stated, the reason they have given, my lord, how I am not, they said we came within the zone of consideration, but you are not eligible to be promoted. The only reason, at one point of time, a shock cause notice was issued. And that shock cause notice was the ground, my lord, that how I am not eligible to be promoted, my lord. If I can take my lord to the affidavit of the District Council.
The one petition or two petitioners here?
One petition.
The other one didn't come?
He hasn't come. Para 8, my lord. Sub-paragraph. At page 3, my lord.
Yes.
Furthermore, the petitioner was issued a shock cause notice dated such and such for negligence of duty, signifying the irresponsibility in the performance of his assigned duties in violation of official norms and direction. Moreover, the petitioner failed to justify the aforesaid shock cause notice, which clearly indicate his irresponsibility. Since the petitioner has come before the court, the writ petition is liable to be dismissed on the ground alone. Further, the principle of merit cum seniority requires the merit be established which the petitioner is found lacking due to negligence and irregularity. Now, my lord, performance report they have annexed at Annexure C, page 11.
Yes.
My lord, my name appear at serial number 3. Irregular shock was issued. Irregular because shock was issued. Now, my lord, these shock was, my lord, this has never resulted into any inquiry. Now, I have filed a, my lord, reply to this. My reply to the affidavit.
Next it your petition?
Yes. No, my lord.
Did you state in the petition that you should show cause at any point of time?
No, because that has not led to anything. That has not.
You have not said it. You're not even passing. You're not mentioned in the petition.
I have not mentioned, but I have explained the situation in my rejoinder, affidavit in reply.
You mean to say that in the period from the time when you filed a presentation, the time the impugn order came out, you're not aware about these whatever happened inside the office?
No, I do not know, my lord. How they have done, I don't know. Now, my lord, if I can take my lord's at page 3, my lord, paragraph 7. That with regard to the statement made in paragraph 8 of the affidavit, it is specifically denied that the deponent initially was upon abolition of the post
page
was
3?
Page 3, para 7, my lord.
Yes.
With regard to the statement made in paragraph 8 of the affidavit, it is specifically denied that the deponent initially was appointed as Assistant Sub-Inspector of Taxation and upon abolition of the said post was redesignated as Sub-Inspector of Tax. It is reiterated that the writ petitioner was promoted to the post of Sub-Inspector of Taxes by letter dated 29/8/2014. That I have annexed. Categorically mentioned that deponent has been promoted to the post of Sub-Inspector taxes. On assuming the post of sub-inspector, the writ petitioner had been discharging his duties and responsibilities attached to the post, besides drawing higher salary than the said post to carry. The allegation of absence from duty 2700 as contained in the show cause notice was not correct. In fact, the deponent, after receipt of the show cause, immediately submitted his reply on 4/9/2019 before the Secretary Executive Committee, High Hills Autonomous District Council, and also apprised them verbally that he was not absent from the duty on such and such, but was on inspection in Banihat and its adjoining areas, along with the concerned inspector, which is part of his official duty, and this was well within the knowledge of the concerned authorities. Following the explanation from the deponent, no proceeding or inquiry has been initiated against the writ petition. This has not led to anything, my lord. Therefore, relying on such show cause and holding the deponent negligent and irresponsible in performance of his assigned duties and taking the same into consideration for not recommending his need for promotion is grossly illegal and unjustified. In the circumstances, consideration of the show cause notice such and such as admitted by the respondent in the affidavit.
There's a reply in handwriting.
Well, I have given the type copy.
No, of course, that's the one you made and you wrote in hand only.
Yes.
That's it.
By hand, my lord, it's written.
With no supporting materials as to your fact of inspection.
No. But the fact is this, my lord, this has not led to any, my lord, proceedings. Now, my lord, this is the only ground. Now, my lord, what the law say, your lordships? Now, my lord, I have just compilations. I've given a compilations, my lord. Now, what the law say, my lord, on this?
Yes.
I've given that. Now, my lord, admittedly, my lord,
the rules at all.
We are rules. I am relying on the rules, my lord. We are admittedly, my lord, governed by this thing, service of district council, gazetted, my lord. This is, my lord, the name of the rules. This is, my lord, this is called, my lord, the Khasi Hills Autonomous District Service Rule 1961, my lord. There is no dispute, my lord. They also admitted we are governed by this, my lord. Now, my lord, coming to 15, my lord. 15. If your lordship, my lord, if your lordship is holding this rule, my lord, 15 it say.
Don't have rules here. You have to give a list of books.
My lord, so far, my lord, the judgment are concerned, I have prepared this complaint.
No, have you given the list of books for them to take out? You didn't give a list of. You do that, give it to the court masters who will know what is necessary.
No, my lord, the admitted position as per, my lord, the 15 is, it's merit cum seniority. My lord, I am not disputing, my lord, it's merit cum seniority. But to be on merit cum seniority, my lord, there has to be, my lord, transparent objective criteria how you made these elections. And if someone is within the zone of consideration, my lord, you cannot, my lord, refuse him promotion, my lord, on the ground of some extraneous consideration. If it is on an extraneous consideration, my lord.
So your ground is that your case that there was. That is the only factor that deprived you promotion. That's all.
This is, they are admitting.
No other adverse.
The other thing, my lord, I'll come if your lordship, how they made
you don't have any ACRs and
no,
there's no kind of
no records. No, this is also there. I have taken those ground. They have not relied on any records. Now, what are the records? They do not mind.
No, whatever is going beyond the records, going beyond the pleadings, also whether they maintain any confidential reports by your controlling officer with regard to your discharge of duties, whether that's placed before the executive committee. See, in every service, there has to be a ladder process as how your service is evaluated.
No, what is
so that's the purposes of even for across the board for how you grant promotion.
Exactly, my lord.
Yes.
My contention, my lord, there is no promotional committee at all. I made a categorical statement in my affidavit. There is nothing is here.
No ACR system.
Nothing. No, they do not have ACR.
District Council does not maintain ACR.
All right.
So I like your face, I'll promote you. I don't like your face.
That's what is
my lord, what we rely upon is the reports from the controlling officers. Whenever there's any promotion, so reports are called from the controlling officer.
So, my lord, my humble submission.
Any chance for him to to repel any adverse entries.
Nothing, no adverse.
There are no entries as such, my lord. That's what my first question to the council was.
So you can't please a controlling officer, you're doomed.
Finish.
But in fact, it's not only the petitioner here, there are many others also more senior. And my lord, my friend has pointed out the performance. This is the performance of the sub-inspector. It's not only that one incident.
No, one thing, just there was a chart I saw just now. Now the ones who are senior to you, they're not aggrieved.
And they have not.
Over the proceedings against them.
I'm the senior most, my lord.
No, you're not the senior most.
Senior most. I'm the senior most. Though in that order, my lord, that order do not tell you with the seniority. It is not on seniority basis. I am the senior most.
Yes.
Now, my humble submission, my lords, is admittedly, my lord, married, so I am not disputing. If it is married, my lord, law permits, even the junior, provided he is more eligible, he can supersede the seniors. But here again, what the Supreme Court has stressed, my lord, in this kind of promotion, you will have to maintain a high level of transparency and objectivity. If you are feeling in that, that means entire thing dependent on your subjective satisfaction. That should not be permitted. So here it is exactly a case, my lord, they are saying on the basis of the show cause. Now, my lord, I will rely on the relevant decisions, my lord. What did it say, my lord? Allegation cannot be a basis, my lord, to refusing, my lord, promotion to an incumbent.
That's a given.
So if your lordship, my lord, if I can take, my lord, to the compilations. Now, my lord, 1973 2 SSC 386. While merit is the criteria, selection become wider and can be abused with less difficulty. Now, that's what, my lord, this is the one of the original decision, my lord. If your lordship look into paragraph 20. There is a, my lord, handwritten running paragraph, running page 22. If I can read that, my lord. It is true that where merit which is difficult to judge is laid down as the sole test for promotion, the power of selection become wider and they can be abused with less difficulty. But the machinery provided for preparation of the select list for promotion to all area services so as to ensure impartiality cannot be assumed to operate as to produce unjust result. The wider the power entrusted to an administrative authority, the more should be the consciousness, responsibility on its part for their due discharge, fairly and impartially. The presumption is that the authority concerned will discharge its obligation with full realization of its implication and honesty. We have, however, to determine whether the selection committee and the Union Public Service perform their function on a correct interpretation of the relevant regulation and not whether they acted honestly about the entertained doubt whatsoever. So, my lord, this position has been, whenever it is merit, my lord, a level of transparency has to come, objectivity has to come. Now, my lord, the next decision, my lord, 1991 4 SSC. Now, it says, my lord, preliminary investigation prior to the stage will not be sufficient to resort to seal cover procedure. Even when, my lord, there are charges pending, even criminal charges pending, my lord, that cannot be a ground to refuse, my lord, not to consider. Even in that case, my lord, you will have to go for seal cover. That is the, my lord, case of 1991 4 SSC 109, page 16 and 17.
Paragraphs?
Paragraph 16 and 17. At page 45 and 46, my lord. And read. On the first question, as lordship, yes. 45. On the first question, namely as to when, for the purpose of the seal cover procedure, the disciplinary criminal proceeding can be said to have commenced.
Here would have application because there was no DP drawn up against.
No DP.
What was the question of seal cover procedure?
All right. That is what I am saying, my lord. I am categorically saying there is no committee at all. No committee.
Fine. So that this judgment will help you.
So now what I want to convey.
A case where there was
what I want to convey.
They didn't have a sealed cover procedure and the
lordship,
superseded you.
True, my lord.
And you were exonerated later on. Yes.
Now what I want to convey,
yes,
my lord, even a criminal charges, pendency of a criminal charges is not a bar for considering. And here, my lord, only a shock cause which has not led to any inquiry, my lord. That happened in 19. And I filed a reply, my lord, matter ended there. And now they are on, by filing an affidavit said you were irregular because of the shock cause. And this is the reason, my lord, I was not promoted. Now I'll take my lords to other decisions, my lord. If I can take my lords to now, my lord, one of the decision, my lord, this is, I think, my lord, touching some district council, if I'm not correct. 2005 2 GLT. This is, I think, my lord, touching some district council lordship. Under Article 16 of the Constitution of India, consideration must be fair. According
compilation?
Yes, it is in the compilation.
Oh, yes, okay.
This is from Aizol, my lord.
Yes.
Paragraph 9. Which is 9?
9?
Okay.
6. I think you've para 9.
Para 9. But somehow I misplaced. I'll just place
You've
it.
just excluded. It's not excluded. This is relevant para.
No, that is the
from para 6 to para 11.
Para 9, my lord. Somehow it didn't miss. I'll just place it before your lordship. And just for time being, we'll go to the next. 2007.
Where's the book? You have it with you there.
2005
GLR.
GLT, my lord. 588. Now that is pertaining to district council only, my lord, from Aizol. Now there it has been said it will have to be fair, transparent, objectivity. Now, my lord, the next decision, I'll just supply, my lord, this thing. 2007 6 SSC 70. Right to be considered for promotion being within its purview. My lord, this is important, my lord, I will rely. Right to consider for promotion being within its purview and effective, purposeful, meaningful consideration. That should be a proper consideration. When you are considering my case and refusing me on the ground of a shock cause, which you are not supposed to enter, that vitiates everything.
When did you retire?
Well, he has more, how many more years service? This is paragraph, my lord, 11 and 14. Page 63. (11 and 14), my lord, you can take. Page 63.
Yes.
Promotion is not a fundamental right. Right to be considered for promotion, however, is a fundamental right, my lord, to be considered when. Such a right brings within its purview an effective,
yes, please read.
An effective, purposeful, and meaningful consideration, suitably or otherwise the candidate concerned, however, must be left to the hands of the DPC. But the same has to be determined in terms of the rule applicable therefore. Indisputably, the DPC recommended the case of the respondent for promotion. On the day on which it was accepted at the bar that the DPC held its meeting, no vigilance inquiry was pending, no decision was taken by the employer that the departmental proceeding should be initiated against him. Number 14, thus there was no bar in promoting the respondent. During the period such and such, no material was placed before the proceeding to take recourse to the seal cover procedure. In fact, none of the existent material, time paragraph 2 of the said circular specifically refers to the submission of charge sheet as of the cutoff date when the departmental proceeding can be said to have been initiated. So here also, my lord, a case charged, there was a decision to charge sheet him, my lord, but that was not before the DCC. Then the Supreme Court said you could not have taken this kind of thing into consideration, and the recommendation without looking into this by the DPC is justified. Now, 2007 9 SSC, state and instrumentals are bound to act fairly, reasonably while considering promotion of an employee. Mere allegation against an employee would not justify keeping a valuable right to be considered for promotion of an employee in abeyance. Page 70, madam. Para 10.
And day of that you ECR.
Yes. If I can, my lord, read para 10 at page 70. Both the appellants, Bandeli Coalfields Limited, are state within the meaning of Article 12 of the Constitution of India. Their action may therefore just satisfy the test of reasonableness and fairness. Although an employee of the state is not entitled to promotion to a higher post as a matter of right, he is entitled to be considered therefore in terms of Article 16 of the Constitution of India. A right to promotion can be withheld or kept in abeyance only in terms of valid rules. Rules operating in the field do not provide that only because some allegation have been made as against an officer of the company, the same would itself justify keeping the valuable right to be for promotion from in abeyance. When the question of the nature come up for consideration before the superior court, the extent rules operating in the field must necessarily be construed in the light of the constitutional scheme of
now the rules, this 61 rules, where is your promotion?
15, my lord, at page 26.
In this rule?
Yes, page 26, my lord. Chapter 3, rule 15. Rule 15, my lord, in the bottom. 1-5.
No.
At page
61 rules.
Chapter 3. The chapter page.
Chapter 3, Rule 15.
Yes, man. Lordship has got it.
Promotion any service.
Chapter 3 deals with general rules.
So you govern by these rules is very general also.
Yes.
Promotion by any grade or post can be ordinary on the basis of merit, comes seniority, after careful examination of character roles, special reports, possibility of eligible. Yes.
So my humble submission, your lordships, this is admitted, but even they admit that I am governed by this, and this is the particular provision they are also relying, my lord 15. There is no dispute, man. And it is merit come dispute, I am also not zoning. Now, my lords, if I can finish this. Now, my lord, come 2008. Now they are saying shock cause, so irregularities. Now, lordship is well aware, my lord. Adverse remark. They do not maintain an SER, some kind of record.
Where?
Without communication.
What you mean?
Lordship.
Devdutt is a leading judgment.
Yes, the Devdutt, my lord.
Yes.
Now, my lord, 2008, any adverse remark, my lord, if it is not communicated, cannot be relied on. Now, my lord, that decision I have, my lord, 2008, 8 SSC 725.
But then there's not a question of non-communication.
They are saying, my lord, the shockers cannot be adverse, my lord.
No, it's not a question of non-communication.
Yes, it cannot be.
But
But
doesn't have any.
Suppose, my lord,
enter any. There's no ECR maintenance.
Appraisal report.
Reports.
Appraisal report is saying irregular because of the shockers. So they are treating it as adverse. It cannot be treated as an adverse. This is a mere an allegation. It has not led to any inquiry and findings. So even if assuming, my lord, for the sake of argument, they are saying this is adverse, then where is the communication? Otherwise, what my lordship is getting, my lord, is correct, my lord. Allegation cannot be an adverse entry. So my humble submission, even otherwise law, it has been well settled. Even if you treat something as adverse, that has to be communicated to the officer concerned. Here, admittedly, no such communication. And in any case, my lord, shockers allegation cannot be an adverse entry. Now, my lord, if I can take my lord to that last decision, my lord, 2010 1 SSC. Now, what happened in this kind of situation? When one person, same promotion, one person, my lord, for some, my lord, extraneous consideration refused promotion, that vitiates entire thing.
Yes.
There is 2010 1 SSC 345.
Para?
Page 90. Page 93, man.
Para?
Para 11 and 12. 10, 11 and 12. If I can read, this is the last page. The appellant submitted that they were promoted in November 1990. They had worked in the higher post of field supervisor for more than 10 years, and therefore, even if there was some procedural irregularity, their promotion ought not to have been interfered with. In the year 2001, the submission is misleading. Though the promotion of the appellants were in November 1990, it was challenged before the High Court by the third respondent by filing a writ petition without any delay. That is, in less than 3 months. The fact that the writ petition was pending for considerable time will not therefore operate any equities in favor of the appellants. 11. The appellants in CA number 789 of such and such have an additional grievance. The 3 appellants in that appeal were originally promoted on such and such date, when the High Court has set aside the said promotion and directed a fresh process of promotion by adopting the principle of seniority cum merit. The bank accordingly made fresh promotion by order dated such and such, and these 3 appellants were again promoted with effect from such and such. But their seniority in the post of field officer were reckoned from the date of their fresh promotion, that is such and such, and the various period of service in the field of supervisor from 1991 was ignored. They contended that their service as field supervisor between such and such should also be counted for the purpose of their seniority in the post of field supervisor, further promotion, and other. It is now well settled that if an appointment or promotion is made without considering the claim of all the available eligible candidates and or without following the relevant rules, the service rendered in pursuant to such illegal appointment or promotion cannot be equated to service rendered in pursuance of an appointment or promotion validly or lawfully made. Whenever a person is promoted to the post without following the rules prescribed for such promotion, he should be treated as a person not regularly promoted to the post. Consequently, where promotions were governed by the rules in computing the length of service in the post of which an employee is promoted, it is not permissible to include the period of service rendered in pursuance of an illegal promotion which is subsequently satisfied. So here is exactly a case, my lord. My case, same promotion. My case, I was refused show cause. My show cause cannot be. It is not even adverse. But even then I have relied. Other than this, my lord, in my affidavit, there is no promotional committee, my lord. There is a appraisal report. Obviously, they have relied on the appraisal report. Now, appraisal report, my lord, saying I am irregular because of the show cause. They have made a categorical statement because of the show cause. So, my lord, that vitiates the entire process, my lord. So, entire process will have to go, my lord, and they will have to, my lord, my humble submission, my lord. I cannot ask, my lordship will give a direction for promotion. Lordship, they need to, my lord, redo the entire exercise, my lord, maintaining, my lord, level of transparency and objectivity. Well, that is what I have stated in my petition also, my lord. There is no criteria, my lord, on the basis of which, my lord, this merit cum seniority has been applied for the purpose of promoting the private respondents. So this is a case, my lord, needs to be interfered with. But my lord, if I can read 9, your lordships, that is with relation to, my lord, in the compilation it was missing. That is relating to, my lord, Lai Autonomous District Council. Para 9. If I can read. Yes. Under Article 16, the right to be considered for promotion is fundamental. It is not the mere consideration for promotion. That is important. But consideration must be fair according to the established principle of governing service jurisprudence. Court will not interfere with the assessment made by the DPC unless the aggrieved officer establishes that non-promotion was bad according to the Wednesday principle mala fide. By the Wednesday principles, it means irrational, unreasonable, in that the decision is so outrageous and defiance of logic or accepted the moral standard that no sensible person who had applies his mind to the question. So, my lord, this is a case, my lord, consideration should be, my lord, is a lawful consideration. Here, what is the consideration? Shock cause, my lord. That wishes entire thing, my lord. So, my lord, this is a case need to be interfered with, your lordships. And they will have to redo the entire exercise.
May I please, your lordship?
Yes.
Your lordship has read Rule 15 of the District Council rules. My lord, the rules specifically says that the reports should be called for the suitability of the eligible officers for promotion and other records. Now, my lord, will also come to Rule 24. 1 second. And another aspect, my lord, before we proceed ahead, your lordship will come to Annexure 5, page 11 of the affidavit filed by the council. The lordship had pointed out whether the seniority
affidavit,
yes, of the dishonored. Respondent 1 to 4. I think this issue will have to be thrashed out before. Page 11.
Yes.
Now, performance of sub-inspector, my lord, we'll see that the petitioner is at number 3. Now, so my lord, if he is at number 3, that means 1 and 2 are senior to, if we go by this list.
No, see, on top is like performance.
No, what I'm saying is that 1 and 2 are above.
Yes.
Above the petitioner. So if this is a seniority list, if his contention is true, then he is also not entitled for promotion.
No, it's not seniority, it's performance. He says that this is not a, and
that's what my lord,
the caption says so. Performance.
We have not specified also in our affidavit. My lord, was filed earlier.
No, but the thing is that you bring a seniority list.
Yes, my lord. That is the most important, because
the most important is how whether he comes on consultation at all,
if
or whether he is eligible.
Yes.
If he is not eligible for promotion, his statements that he's not annexed any gradation list also.
No, and we also have not. My lord, this has to be thrashed out, because if
no, we are saying that I say I'm the greatest in the world. Yes. You can say anything. It doesn't mean that you are.
Because if 1 and 2 is senior,
I have set out. My lord, I have set out at para 8 the table.
From the records.
Yes.
Table with the date. Table with the dates of joining.
We have to get from the records.
8 and 9, my lord.
Joined
yes, my lord. They have not disputed this. No, in my read petition, they have not disputed that.
Where's the para 8?
Para my lord, page 8, para 6.
Okay.
It start at page 9.
Para 8, page 6.
Page 9. Page 9. See, my lord, my date of joining the post, 2/9/2014.
Sub-inspector, what about your...
Sub-inspector, now we'll go to inspector, my lord. So there is no dispute, they have not questioned this. All other joined March after me, my lord, 16, 17, 20, 19, 20.
Not ones were given, which year?
Joining and date of joining and gradation list.
Hillary is now 19.
19.
And then the other one is
10.
10 last.
P Diamond lang maroon. No, Makstar
Warjiri. These
10, 20, 20. So those who are bottom, they were given. And I am, my lord, they have not.
Must be exceptional officers.
Exceptional. What is the basis, I got?
So even if we, by this...
You kindly produce the,
yes,
you're maintained by the office, yes.
Because the date of joining and gradation lists are completely different.
Yes.
Because if the gradation list is
as other submissions on other points?
But, admittedly, the ACRs are not there. So this book.
So and your rule doesn't provide for ACRs also.
Yes.
But then General Service Jurisprudence demands that you have to have the kind of committee that that sits and decides on your promotion. And all the people who are in the zone of consideration are, their records are placed.
That ought to be the, yes.
Yes.
To that extent, I agree. That
has to be fair. It has to be fair. Other thing. You can't just because a person is voiceless, you condemn him forever to serve one post.
What the district council, what the executive committee has been doing all along is relying only on the reports of the officers concerned, supervising officers, and it's on that basis that
I think it's time.
Yes.
Now, like you can advise them that even with our recruitment, In
fact, my lord, my advice, even the service rules
are
have
very to be revamped for every year. They have to be done in a proper manner. Now it's 2025. And how many years this council? 75 years now. 52 they came, right?
Yes. And the service rules also are of 1962.
Yes. And law dynamic, yes.
So my lord, let me just clarify that point.
Just clarify the point. Yes, Dr. Mozika. How do you sustain your promotion.
But the executive committee has taken the decision. Lordship kindly sees page 16 of our affidavit. My lord. Affidavit was 5 and 6.
But why give it notice?
What's your head?
No, where's 5 and 6? Yes.
Page 16.
Yes.
So, Office of the Executive Committee, page 16.
Page 16. No, where the lecture?
Lecture 5.
Yes.
Office of the Executive Committee, my lord. Produce that records of all existing sub-inspectors, sub-inspector tax in the Department of Council. Produced also the report along with suggestion of the Taxation Department for promotion to the registered vacancies for the post of inspector on the basis of good performance and competency as per records available with the department in their assigned duties. On examination of the suggestion is found, the department is recommended that Sri H.U. Malan and M. Wadri, both sub-inspector tax, due to their outstanding performance, responsibility with competence, along with dedication, punctuality in their present post as sub-inspector tax for several years. Hence, after careful examination of the records and suggestion of the tax department, this committee has, on the basis of merit cum seniority, affirmed and recommended that Sri H.U. Malan and Wadri are deserving and incumbents for promotion and accordingly promoted. Now, madam, kindly see next page, madam. This is the report that was submitted by the tax department.
Otherwise,
some of the judgment which I have cited, I'll demonstrate, madam. All the judgments are pertaining to where the criteria seniority and merit.
yes. When we will bring the just we'll produce the if there's any records available at all.
1 week's time, my lord.
Just hearing inconclusive just after 1 week to allow the senior counsel for the district council respondents to produce relevant records. Maybe we can pass some orders also where calling for a more structured process. Yes. Otherwise,
for future, madam.
For future.
Yes. No, my lord, what is disturbing this performance report?
No, this is a council. This is a council.
Take that comparison.
Item number 24.
But in this case, the respondent must give some instructions.
Receive instruction. Instruction just stated that he would have to satisfy himself whether the grant of compassionate appointment is justified, having regards to the number of dependents, assets and liabilities left by the government servant, income of the earning member. Lordship, we have not yet able to ascertain the income of the earning member, your lordship. And lordship, from what I've been informed, that the petitioner is married and she's also have a child, your lordship.
So, my lord, here the position is that the steering committee has found her suitable for being appointed.
Lordship,
we've thrashed that how many times, Mr.
Yes.
Lordship, at the end of the day,
Every time for last 6 months the matter is pending only in the point of instruction.
Where was the karma plan?
Lordship, there's some family emergency, lordship. Family emergency, lordship.
We have a bit short of time, Mr. Siddiqui, because we have
yes.
We'll take it up next week.
Yes,
yes?
After 2 weeks, lordship.
1 week, 1 week. If you are there, Ms. Karma is there or not. I request a party list up to 1 week. That's no hearing.
25.
What has happened to this?
Lordship, let this matter be referred to the mediation, your lordship.
Refer mediation. You got a Bijini complex.
Lordship, yes. Then let it, just let me obtain the instruction from them. Let it come up tomorrow or day after? Not day after, my lord. If it can be tomorrow or Friday.
Yes, Mr. S. and their counsel for the petitioner prays that we will have to obtain instructions as to whether the matter can be referred to mediation. This tomorrow. Let's say after then. This on Thursday.
No, my lord, Thursday will be some
It's on Friday.
Friday.
Apply, your lordship.
Well, there is the interim order, my lord, to continue.
Interim order continue for the orders.
26.
My lord, this is a matter.
Not arrest.
Arrest, my lord. My lord, it has taken a little bit of a serious turn now. We had filed an application to preserve the CCTV footage. Now, my lord, the CCTV cameras to be installed, my lord, has come down after an order from the Apex Court, Honorable Supreme Court, my lord, in SLP 3543 of 2020. My lord, the guidelines are very strict. The state of Meghalaya has also filed an affidavit in the Supreme Court saying their status, right from 2020 and 2021, my lord. So, my lord, over here, my lord, we will have to implead the SHO, the OC of the concerned police station as a necessary party because as per the directions of the Apex Court, my lord.
Where's the police station?
Bajingdoba, my lord.
Bajingdoba?
Not Garo Hills.
And CCTV?
My lord, but then they have CCTVs. What they have said that due to low voltage, it is not functioning. And
I was just going to say that.
That is not possible, my lord. The whole police station was functioning and the issue with regards to electricity.
Anyway, you implead, yes, Mr. Shulai.
Let him implead your lordship.
Mr. Khera,
my lord,
the outset prays that he may allow some liberty to file an application to implead further necessary parties.
My lord, I have one more leg to this argument. My lord, in the meantime, the affidavits have been filed by the state in the Supreme Court, where they have categorically brought about, because it is this very reason for which the Apex Court had intervened for the installation of the CCTVs and everything. So they may bring on record all the affidavits with respect to the installation of CCTV.
No, that will see. You filed for the application. This after 2 weeks, yes.
How long you lost?
28.
That affidavit is public domain. You can get it. Yes.
Well, nothing survives in this writ petition. Well, it is that regarding the printing of...
Oh no, this is regarding that smart card. Yes, Mr. Deb.
Lordship, what they have done is, my lord, they had...
You file a suit.
They have taken a premeditated decision, Lordship. They have not even considered a single...
You can't enforce a contract. Pacific Relief can't come here. And you would draw with liberty to take private law remedy.
Lordship may give that I will seek compensation, Lordship.
That will come under the civil proceedings only.
Yes.
Mr. S. Deb submits that.
I'll not withdraw it, Lordship.
Yes. We will not withdraw, right? Then we'll did it.
If my submissions, if I may just take, I'll take 5 minutes, Lordship, just to.
No need to record submissions.
Because what they have done, Lordship.
Petition has been filed. Assailing the.
It's the order of.
Assailing the termination stroke cancellation order dated
10 September 25.
10/9/2025, whereby the petitioner's work order stroke contract dated 12/5/2023 for what is it? What is
printing
your
of the smart trading license?
Printing of
smart
trading license.
Of smart trading license has been cancelled. Stop. This court has examined the Mr. S. Deb, legal counsel of the petitioner, has submitted that the cancellation is unwarranted and is purely an arbitrary action which is premeditated and as such seeks this court's interference and also for payment of adequate compensation. Stop. Next paragraph. Mr. T.T. Dindol and the senior counsel, one of the respondents, has submitted that the petition is not maintainable as it is purely in the realm of private law, and that the petitioner has the ability to seek alternate remedy if so aggrieved. Having heard the counsel parties also examine the materials on record, it appears from the query itself that the grievance of the writ petitioner is only for directions or grievance only the cancellation and further to allow the writ petitioner to continue the work in terms of the contract dated 12/5/2023. Stop. Also noted is the prayer for compensation. Stop. Next paragraph. The considered view of this court, reparation for specific performance will not be maintainable. So also for compensation which is yet to be computed, or whether or compensation which is in the realm of private law. Next paragraph. For the reasons said, reparation shall be not maintainable. The same is dismissed. However, with liberty to the petitioner to seek alternate remedy under private law.
Much
Obliged.
So you wanted a reason order.
Lordship. Because now they are doing it departmentally, so.
Okay.
Obliged.